this and to answer our questions and to give us an update on what HB2827, what's happening with that in Illinois. So I'm going to hand it over to Will very quickly, and thank you.
Well, thank you so much. It is an absolute privilege to be here with all of you in Illinois. Thank you for coming out today, even though we haven't had to do witness slips in a couple of weeks. I mean, are you even an Illinois homeschooler if you haven't had to do a witness slip in the past week or so? But as it was said, I'm Will Estrada. I'm Senior Council at the Homeschool Legal Defense Association, and you all have really just captured the energy, enthusiasm, and inspiration of homeschoolers, not just in Illinois, not just in the United States, but in the world. I've had media inquiries from Times of India, from reporters all around the world, and people have asked me, why is it that this battle in Illinois has really captured the imagination of people everywhere? And I think there are two things. I think one of them is that the bill was just so bad. It's the worst bill I've ever seen in my life. But I think the second thing, and the bigger reason, is because of all of you. When the bill was first introduced, one of my good friends who's been in Illinois home education for a long time said, Will, I don't think we're going to be able to beat this bill like we did in 2011, because I don't think the homeschoolers of today are like those homeschoolers back then. I don't think they know freedom. Now, I'm a perpetual optimist, so I was like, well, we're probably going to lose, but we'll go down with the flag flying. Perpetual optimist, right? And none of us were expecting the response that you all brought on March 19th, when so many homeschoolers came out to the Capitol in Springfield that they had to shut down the Capitol. A fire marshal did. How many of you were there on March 19th? That's awesome. Okay, that's some good numbers. Were any of you at the press conference? Okay, that's good. You guys are rock stars. Were any of you there at the second hearing recently? Okay, that one was came out the last minute. But you all really drove that. You coming out, you standing up, you answering the call. That is, I think, what has really driven just the intense interest in this, because you all came out and fought for freedom. And you have inspired people everywhere. You've inspired me, and it's been absolutely incredible. So what I want to do today is I want to take a quick step back from HB 2827. I want to talk about some of the key court cases. It's going to be really fast. You're going to see how People versus Levison fits in. Then I'm going to real quick fly through what the bill does. You all know what the bill does. And then I want to open it up for questions, because I know there's a lot of questions. Is the bill dead? Is it like mostly dead, Princess Bride level dead? Is it Lazarus level dead? Is it zombie level dead? Or is it dead? No one really knows. But I know that's a question. I know you probably have other questions as well. So we'll dive in, because I want to leave plenty of time for questions. Aha, there we go. It's far away, so you can email me at will.estrada@hslda.org. I'll send you this PowerPoint and any other resources that we talk about, so feel free to follow up. But a little bit about HSLDA. We were founded in 1983. We work very closely with state organizations, and we have some friends from Ad Hoc. Any of you ever heard Kirk Smith talk about Ad Hoc? Would you stand up, please? Let's give Ad Hoc a round of applause. We thank you. Do we have any representatives or volunteers from ICHE here? I don't think we do. I told Kirk Smith, I was like, I'm coming to Illinois if you're around. But thank you for what you're doing at Ad Hoc. We work very closely with state organizations. We work closely with just homeschoolers, with other allied organizations. But when HSLDA was founded in 1983, homeschooling was illegal in most of the 50 states, but not in Illinois. And there were actually homeschoolers coming from Texas and Missouri and Indiana and as far away as Iowa to come to Illinois because of the People versus Levison decision, the homeschool decision from 1950. So kind of funny, nowadays people are like, we're leaving Illinois. Back then in the 70s and 80s, when homeschooling was having the resurgence, people were coming to Illinois for homeschool freedom. But that was the environment in the early 1980s. Parents were being thrown in jail. They were being prosecuted simply because they were exercising their God-given fundamental right to homeschool their kids. So kids, I see a lot of kids here. If you were my age, Your parents would do weird things. Like you would all get in the van, you would drive down the store when school would come in, you'd park in the cul-de-sac behind your house and sneak through the woods and then do your homeschooling in the house. And you're like, that is weird, no one would do that. I have talked to so many homeschoolers who that's what they did in the 80s and early 90s because they were so afraid of people turning them in for simply homeschooling. And today, homeschooling is mainstream. Some of the legislators in Springfield and a little closer need to remember that homeschooling works and it's successful. We have almost 100,000 member families. We're a public interest advocacy and law firm. We work at the state, local, federal level. I spent 12 years as HSLDA's federal lobbyist, and now I'm one of the state attorneys as well. I was a legal assistant, so I've kind of done everything in the organization. I've done 21 years at HSLDA. Sounds like a prison sentence. No, it's a good thing. I love what I get to do. And then quick picture of my wife Rachel, also a homeschool graduate, our two boys, Dominic and Merrick, and our dog Daisy that you might have seen in one or two of the videos that I did. Daisy is a wonderful rescue dog. Fun fact, I'm not a dog person. My wife grew up with a bunch of dogs. But I'm like, I'm gonna mess up the house. I do all the house cleaning in the house. Husbands, this is a good pro tip, by the way. Get the kids doing the housework too. And I'm like, and if it's a dog, we'll have to sweep and vacuum all the time. So my wife and kids have been lobbying for years to get a dog. And I was just like, no, we'll have a cat. Cats are terrible. I love them, but they're terrible. And then we're down at my wife's younger sister's horse farm in Louisa, Virginia. We live in Northern Virginia, where HSLDA is located. That's where we homeschool our kids. And they had a crazy golden retriever puppy. And the kids are playing with the puppy. The puppy's like flying over my head and just a crazy golden retriever puppy. I'm like, this is great. They're all gonna see how crazy dogs are and they won't want a dog. We're not 500 yards down the road. And Rachel's like, we need to get a dog. And of course, Dominic and Merrick are like, we need a dog. And I was like, sure, go get a dog. And I was thinking, nah, that won't ever happen. A week later, we're going to visit this dog from the rescue, been rescued from a kill shelter, actually. And the kids are like, I hope we get the dog. You know how dog rescues, they send these sad pictures of the dog, like tears coming down its eyes and droopy ears. And it's like, only you can save the dog from Anthony Fauci or whatever. I shouldn't say that. I shouldn't say that. They send the picture around, and my kids are like, oh, and they're praying every night that we'll get the dog, and I'm praying too. The other way. And then we're driving there to go pick up the dog. And they're like, do you think the dog is going to be good? I'm like, well, some of these dogs have been abused, and so don't get your hopes up. But we'll see, and it's in God's hands. We get there, and the dog comes out, and dog just comes and lays at our feet, and its tail is wagging. I'm like, this is a good dog. And so we've adopted Daisy. She's a wonderful dog. She doesn't like Amazon drivers, which might be good for our budget. But other than that, she's a good dog, and you've seen her in our video. Fun fact, I was in high school debate. In fact, I see Emily back there, who was also in high school debate. And the last time I saw you, Emily, was 25 years ago? Doing high school debates. So I didn't actually come out this way, but a lot of the Naperville homeschool high school debaters came out to the East Coast for some of the debate tournaments, or Nashville. So I was homeschooled K through 12, oldest of 8 kids. Dad was a public school teacher. Mom gave up her career in IBM in New York and in Pennsylvania, which are the two worst states to homeschool legally, but there are many homeschoolers there. So I always encourage people that we're fighting to stop bad legislation, but we will never stop fighting to defend your right to be able to educate your children in the courts. And Pennsylvania and New York do have thriving homeschool communities, so we'll talk more about that as well. Okay, enough of our remarks from our sponsors. Let's get into a quick 5-minute summary of 100 years of U.S. Supreme Court precedent. I could give a whole speech about where our parental rights come from. I recently wrote a law review. You can find it. It was published by Liberty University School of Law. It's called Homeschooling, a Seismic Victory for Parental Rights. It was published last year. I tried not to be too wonky, like, lawyers are using big words and all that sort of thing, because I wanted it to be understandable for kids. And I go back into Jewish scriptures, Christian scriptures, Islamic scriptures, the Greek philosophers, the Roman philosophers, the English common law philosophers. I love history. So I give, a review of parental rights from the dawn of time to today. So you can go read that later. But what I wanted to talk about is some of these Supreme Court cases. There are 4 where the U.S. Supreme Court has really established that parental rights are fundamental. That means the highest level of rights. The first one was 102 years ago, Meyer versus Nebraska. That's a picture. By the way, let's see if we have a laser here. Oh, we do have a laser. I love lasers. Oh, wait, you can't see the laser. There we go. You remember that line in Toy Story where the pig is like, what, did you have a laser? He has a laser. So that's Robert Meyer. Robert Meyer was a teacher in a one-room German school, or one-room schoolhouse in Nebraska, and his case went up to the Supreme Court. Then, of course, Pierce versus Society of Sisters, 1925. June 1st is the 100th anniversary of the Supreme Court ruling on that, so get ready to celebrate with that. Wisconsin versus Yoder, the Amish and Mennonite in 1972, and then the most recent parental rights case the U.S. Supreme Court has had was 25 years ago in Troxel versus Granville, which was a grandparent visitation case. There is a case pending before the U.S. Supreme Court right now, Mahmoud versus Taylor. It comes out from one of our local school districts close to where we live, Montgomery, what county is it? Yeah, Montgomery County, Maryland. And the public schools had such an awful curriculum that pretty much every single family opted their kid out of it. And the school district said, no, you may not opt your children out of this curriculum. And so a coalition of Muslim, Jewish, and Christian parents, they're represented by Beckett Foundation, they went up to the U.S. Supreme Court that this challenged their parental rights and their religious liberty rights. And oral arguments went very well. It might even be a 7-2 victory for the family. The question is, nerdy lawyer here, is if it's going to be a parental rights case or a religious liberty case. If it's a parental rights case, we will have another big case for parental rights. So keep your eye out for that. We'll probably get a ruling on that in June. Robert Meyer, let's talk about him first. So Meyer versus Nebraska, in the early 1920s with industrialization, immigration, World War I, anti-German sentiment, a lot of states were passing laws saying you can't teach kids any other language other than English. Robert Meyer was an instructor in a one-room schoolhouse, and he was teaching German immigrants to read using Martin Luther's translation of the Bible. He was convicted, he was sentenced, he appealed, and here's what the Supreme Court said, and I'm going to read it because it's a little fun. The individual has certain fundamental rights which must be respected, blah, blah, blah. These rights include to establish a home, to bring up children, to acquire useful knowledge, to marry, to worship God according to the dictates of his conscience, and generally to enjoy those privileges long recognized at common law as essential to the orderly pursuit of happiness by free men. Kind of a weak understanding of parental rights, but it was the first time the U.S. Supreme Court ever had to have a court case dealing with parents versus the state. And 7-2, the justices overturned Robert Meyer's conviction and said the parents get to choose what school to send their kids to. Fast forward 2 years later, this is one of my favorite cases. We're coming up on the 100th anniversary on June 1. The Ku Klux Klan once was a very potent force in American politics. And in Oregon, they were so organized that they got a law passed banning private schools. Not just limiting or regulating private schools, it was an outright ban on private schools. Interestingly enough, a lot of this was due to anti-Jewish sentiment, anti-Roman Catholic sentiment, and they said, we want to use the public schools to teach kids to be Protestant against their parents' views, who might be immigrants from mainly Eastern Europe at that time. And 2 private schools filed suit. One was the Society of Sisters, you can probably tell from their name, a Roman Catholic private school, and one was a sectarian military boarding school. Case went up to the U.S. Supreme Court, and in really what I think is the most quintessential and fundamental parental rights case, the Supreme Court 9-0 struck down Oregon's law, and they said the fundamental theory of liberty, upon which all governments in this union repose, excludes any general power of the state to standardize its children by forcing them to accept instruction from public teachers only. The child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations. And 9-0, the U.S. Supreme Court struck down this draconian law in Oregon. Now, we interrupt these Supreme Court cases to bring you what is the most important case in Illinois, and really what set the stage for the laws, this case 75 years ago, for how we educate our children at home today in Illinois. In 1950, there was a family, the Levison family. Marjorie Levison is the mom. I actually don't know Dad's name. His name is not recorded in the court documents. They were Seventh-day Adventists. They were convicted under the criminal truancy statute. Does this sound similar to the debate over HB 2827? Because they kept their child at home, their oldest daughter at home, to homeschool her. The interesting thing is the Levisons both, and again, 1950, not everyone had college degrees, both had college degrees, and Marjorie Levison actually had experience teaching, and her husband had experience teaching. They had a very rigorous homeschool program. There was no debate in the trial court of were the children doing well, were they doing poorly. It was just simply, could they homeschool their child? And they were convicted. They would have faced fines and prison. The Illinois Supreme Court overturned the decision. It was a split decision. I'm actually going to include a line from the dissent. But the majority found that no, the parents had the right to homeschool their children, and they cited the Meyer decision, Meyer versus Nebraska. Here's what the court said. They said that they found the parents believed that, quote, the necessary atmosphere of faith in the Bible cannot be obtained in the public school, and that for the first 8 or 10 years of the child's life, the field or garden is the best schoolroom, the mother the best teacher, and nature the best lesson book. Does that sound like... Some people don't like unschoolers, but that kind of sounds like unschooling right there. Hopefully I'll get re-invited here, talking about unschooling, different philosophies of homeschooling. And then the court went on. They overturned the conviction. By the way, that's a picture of Marjorie Levison, her oldest daughter, the one on your left. That's the one that they were homeschooling at the time. She was in 3rd grade. And the one that the conviction was for not sending her to public school. And then the younger daughter, they ended up homeschooling her, but she was not yet of compulsory attendance age at the time. So that's from 1951. And that's Marjorie Levison right there. The court continued, and this is kind of the money quote of how HB 2827 flips compulsory attendance laws on their head, but also how it conflicts with People versus Levison. The court continued. Compulsory education laws are enacted to enforce the natural, again going to fundamental rights, natural obligation of parents to provide an education for their young, an obligation which corresponds to the parent's right of control over the child. And then Meyer versus Nebraska, going back to the fundamental case. The object is that all children shall be educated, not that they shall be educated in any particular manner or place. And this is what just irks me about HB 2827. There's a lot of things that irk me about the bill, but in particular, this provision. They're flipping compulsory attendance and truancy laws on their heads. The purpose of compulsory attendance and truancy laws are that children are to be educated, as People versus Levison said. Not that children go to one set school. That's what we fought in Meyer versus Nebraska and Pierce versus Society of Sisters and the other cases. HB 2827 flips it and says if you don't turn in this piece of paper, you're violating the compulsory attendance laws and you could be prosecuted. The amended version says referred to the state attorney for potential prosecution if you don't fill out this piece of paperwork. There's no question of what is the quality of the education. There's no question of are you educating your children. I mean, it's such a, I'm going to restrain myself. It's such a not thoughtful bill that you could have an 11th grade, let's say an 11-year-old who's doing past high school level, let's say they're a prodigy, and you could be prosecuted for failing to follow the compulsory attendance law simply because you didn't turn in this homeschool notification law. That is not the purpose of these laws, in my opinion, and in the Illinois Supreme Court's opinion as well. The court went on, if a child is attending a private or parochial school where children are taught the branches of education, taught to children of corresponding age and grade in public schools, and where the instruction of the child in the branches of education is in the English language, the child shall not be required to attend public school, and the child is in compliance with Illinois compulsory attendance laws. And then the court went on and said homeschools that meet these two requirements are considered legal private schools. That's why we always say technically we're not homeschooling in Illinois. Technically, you are a private school, so I try to say, I mess up all the time, I try and call it home educators instead of homeschoolers in Illinois, just to be hyper-technical. Now, this second paragraph, though, is important because when the supporters of HB 2827 say, there are no rules, people can do do what they want. Kids are being left behind on their education. They're wrong. The Supreme Court in People v. Levison gave a platform for truant officers to prosecute families if their kids are not being educated. The court made it very clear the parents must, in good faith, provide an adequate course of education. There's other language about a commensurate level to the education of kids in a corresponding grade level for that grade level. And the court even went so far as to say if a family is prosecuted, they have the burden of proof to show evidence that they're providing a commensurate education. So just to go down a rabbit trail here, as you know, in Illinois, and this is not unique to Illinois, there's a massive truancy problem. These are all public school students who are still on the books, enrolled in the public schools, and they're just not showing up to school. It used to be mainly older kids, 15, 16-year-olds, but post-COVID it's been even younger kids. In DuPage County, for example, there are 700 active truancy investigations. There are 5 truancy officers. So when I testified, when other people testify that this is an unfunded mandate on the regional offices of education, it's true. They can't get public school kids who are habitually truant back into the classroom, and the evidence shows that these are children who are vulnerable, who are at risk to abuse and neglect, let alone educational neglect. So Tara Costa Howard and other supporters have said, and if a truancy officer goes and does an investigation, the family says, oh, we're going to start homeschooling, there's nothing we can do. That is not correct, because as the court established in People v. Levison, the authorities do have the authority and the legal duty to then say, okay, prove to us that you're homeschooling. Do you know why they don't do that? It's because they're happy when a family unenrolls from the public school and goes through with as a homeschooler. Then they're like, oh, thank goodness, we don't have to report them as someone who's habitually truant. We don't have to send resources on them. They dust their hands. They're not our problem. You go talk to a truancy officer, that is what is happening. They have the legal authority right now to go and see if those kids are actually being educated, but sometimes they even push families into homeschooling because they don't want the problem of trying to get them back into school. That's what's going on. That's really the situation. If they wanted to, they have the legal authority to go after these families who are habitually truant, who then at the last minute say, oh, actually, we're homeschooling, because they're really not. They're using that as a loophole. It's you guys who are homeschooling your kids. Those are the ones they're trying to go after, when it really should be the families who are habitually truant where there's not education happening. Let's stay on course here. The court went on. This is a great slide, not going to read it all. They say the child's being taught the third grade subjects, has regular hours for study and recitation, shows a proficiency comparable with average third grade students. The court went on. There's nothing to indicate that the education is being neglected. And then I love the line that they say, we think the term private school, when read in the light of the manifest object to be attained, includes the place and nature of the instruction given to this child. The law is not made to punish those who provide their children with instruction equal or superior to that obtainable in the public schools. It is made for the parent who fails or refuses to properly educate his child. So again, they have the authority to go after people who aren't educating their children. Just as an aside, as your friendly lawyer, this is why we encourage families to keep records of what they're doing. Even though Illinois has great homeschool laws, this is why I always tell families, you don't have to give it to the school district, but keep records of what you're doing. Work samples, as you would do in a state that has high regulation. You're never going to show it to anyone, but it provides evidence in the very unlikely event that a truant officer did come and say, well, we don't think any education is happening here. Fun fact, in 5 years, we have only had one school district that's come after an HSLDA member family. It was a false allegation of educational neglect. The regional office of education contacted them and said, you need to bring all your work samples to the regional office of education so we can see if an education is happening. We got our local council involved, Jeff Lewis, who's president of ICHE. I love ICHE. They do great work. If you know Kirk Smith, I call him Captain Kirk, and I told him if the bill goes down to defeat, I'm going to promote him to Admiral Kirk. But we got Jeff Lewis as our local council involved. We sent a very nice letter to the regional office of education. We said, well, this is a criminal statute. Do you have probable cause that the family is not educating their children? And we never heard anything back, because it is a criminal statute. And the government can't just do a fishing expedition on your fundamental right. They have to provide probable cause, and if they did, the family did have all their records, then we would have happily given that. Or if people were, oh yes, people, this is dissent. And I am very glad that obviously the family won in People versus Levison, but I wanted to put the Justice Simpson's dissent in because as I was reading it from 75 years ago, it's exactly the arguments that we're hearing today from the supporters of HB 2827. I encourage you to actually Google People versus Levison. It's funky spelling, Levisen. It's not a long case. It's a really encouraging case, but the dissent is really interesting. I mean, the Justice Simpson, long dead, has passed away, but his disdain for anything that's not traditional education comes out. Traditional public school education. Technically, homeschooling is the default traditional education. And this line was very telling. What will be the position of the truant officer when he is told by parents that their child is receiving proper instruction at home? And then he quotes a case from Washington State, which had been against homeschooling. Washington was very bad since actually 1912 when it came to homeschool freedom. And here's the line that he quotes with approval from the Washington Supreme Court. We have no doubt many parents are capable of instructing their own children, but to permit such parents to withdraw their children from the public schools without permission from the superintendent of schools and to instruct them at home would be to disrupt our common school system and destroy its value to the state, end quote. Because this battle over HB 2827 is not a new battle. It's that fundamental battle of really two things. Where do our rights come from? Do they come from, as our founders said, endowed by our Creator with certain inalienable rights, or do they come from the state? There's whole philosophical debates about that. I talk about them in the law review article that I wrote. But if our rights come from the state, then the state can take them away. But if our rights come from our Creator, then we are endowed with them, and nobody can take them away. I joke with my kids all the time. I'm like, what kind of a country do we live in? And they're like, they know now. They're like, a free country. So the other day I was like, go clean your room. They're like, we live in a free country. I'm like, no, it doesn't work that way. But we live in a free country. We are endowed by our Creator with certain inalienable rights. And homeschooling, parental rights, the rights that you have, the rights that your grandchildren have, the rights that your great-grandchildren, by God's grace, will have, the rights that our grandparents had, those first start with the understanding that children are a gift from the Creator, gift from the Almighty, that we are there to be responsible to raise and prepare our children, and they're not the state's children. But this philosophy of Justice Simpson, its benefit to the state, is what Coalition for Responsible Home Education has. It's what the sponsors of HB 2827 and the supporters of it have. It's a worldview that is deeply antithetical to what we have as homeschoolers. And it's not new. It was here in 1950. Sorry for the small font. Wisconsin versus Yoder, jumping back to those U.S. Supreme Court cases, was a wonderful case from 1972. The interesting thing is this was not a conservative court. A year later, they would give Roe versus Wade to the nation. But in 1972, Wisconsin had passed a law, compulsory attendance law, and they prosecuted Amish and Old Order Mennonite families because they withdrew their children after 8th grade. And in a ringing announcement, the U.S. Supreme Court reversed their convictions and said this case involves the fundamental interest of parents as contrasted with that of the state to guide the religious future and education of their children. The history and culture of Western civilization reflect a strong tradition of parental concern for the nurture and upbringing of their children. This primary role of the parents in the upbringing of their children is now established beyond debate as an enduring American tradition. Incidentally enough, Wisconsin versus Yoder with the Amish and Old Order Mennonite, I've been dusting it off again because if HB 2827 passes, as you know, Illinois has a very large Amish and Mennonite community. It would be kind of our argument to defend those families as well as religious homeschoolers, home educators, who did not want to follow HB 2827. And then most recently, 25 years ago, Troxel versus Granville, which was not really an education case, it was a grandparent visitation case out of Washington State. The Supreme Court made this ringing announcement. The liberty interest at issue in this case, the interest of parents in the care, custody, and control of their children, is perhaps the oldest of the fundamental liberty interests recognized by this court. In light of this extensive precedent, it cannot now be doubted that the Due Process Clause of the 14th Amendment protects the fundamental right of parents to make decisions concerning the care, custody, and control of their children. That's the legal framework that we have. That's what HB 2827 is trying to go up against. And it's important also to recognize that those are the cases we would litigate on if HB 2827 were to become law. Handy map there. I'll use my laser because I like it. Oh man, the laser doesn't show up on the, what good is a laser that doesn't show up? Well, yes, right there's the map that you can obviously see, but I like using my laser. So Illinois, as you can see, is in very good company. Remember, the supporters of HB 2827 were always like, 38 states, 38 states. I can say that in my sleep now. Have laws like this one, which is not true, and I'll talk about that. But as you can see, it's not just states like Texas or Wyoming that have no notice requirements for homeschooling. New Jersey, Connecticut, Michigan are also states like Illinois that I would not categorize as Republican-leaning or conservative states where there is no requirement that homeschoolers get approval from the government in order to homeschool their children. You don't have to file a notice of intent. In fact, the trend has been to reduce requirements. Vermont recently, they got rid of a lot of their requirements. Vermont, again, is not what I would categorize as a Republican-leaning state. They got rid of a lot of their requirements, and this actually came from the Vermont Department of Education because they said, we're tired of all this work. There are so many homeschoolers, we don't want to do all this paperwork. And the homeschoolers said, yes, we agree with you. Wyoming also, it used to be an annual notice of intent state. They just got rid of that. Wyoming has joined Illinois now as the 12th state that has no annual notice or filing requirements in order to exercise our God-given fundamental right to homeschool our children. So, handy map there. One interesting thing, and this might be an issue of debate, but want to give it to you as encouragement. The first version of HB 2827, there's no question, Illinois would have been the worst state to homeschool. The automatic criminal penalties, a judge would have said, I'm sorry, your father just died, but the law says you have to file it by August 1st, and you got a 10-day grace window, and sorry, the mail stacked up, you're going to jail for 30 days. Go talk to your legislators if you don't like it. That happens all the time in truancy courts where we're defending families, where the judges say, I'm sympathetic to you, but I can't write the law. I'm just a judge. This is what the law says. So the first version of HB 2827 would have been the worst law in the nation. The second version, as you know, it refers the family to the state attorney for prosecution and investigation if the family doesn't file their notification form now by September 1st. So I can't honestly, this is Will Estrada saying, and others might have different opinions, I can't honestly say in good faith that HB 2827 would make Illinois the worst state to homeschool. I think you'd be up there with the top 4. So you'd be a red state all of a sudden, which would be a shock to the system, going from green to all of a sudden up there with New York, Pennsylvania, Rhode Island, and Massachusetts as one of the 5 most regulated states. So that's my opinion. Maybe I'm wrong about that. I'm going to breeze through this rest of this summary real fast because you all know this. This was actually written by a really good homeschool mom. She's a friend of mine here in Illinois, and she sent me this PowerPoint, and I was like, this PowerPoint is so good. Can I share it? She was like, yes, use it. So thank you. To her who sent this to me. It's the first version of the bill, so when you ask for the PowerPoint, just keep in mind some of it changed with the second version, but it's an unprecedented attack on parental rights. It would apply unnecessary government oversight. Again, this bill is not necessary. Some of you might remember in 2011 there was, if I'm remembering correctly, the number HB 136, right? Was that it? Okay, I know you were heavily involved in ad hoc in fighting that one. And that bill was just a simple, like the sponsor says all the time, just a simple notification form. You have to send in this paperwork. There was no criminal penalties, no referral to the state attorney in it. And 4,000 homeschoolers came out to Springfield, and the bill got 1 vote in committee and died in committee. So this bill, HB 2827, goes far beyond what we've ever seen in Illinois before, and it's honestly goes far beyond what we've ever seen introduced in any other states. Some of you might be familiar with Coalition for Responsible Home Education's Make Homeschool Safe Act. It's a model bill. HB 2827 was just as bad as that model bill. It didn't have everything the model bill did, but Coalition for Responsible Home Education, if you're familiar with them, they are the Massachusetts-based lobbying organization. It's a pro-authoritarian, pro-government control organization. they're all ex-homeschoolers who are with this organization. They are the force behind this bill. They drafted it, they have been lead proponents of it, giving talking points to the supporters, and they have been all over social media claiming credit for the bill. They recently said the bill sadly died this year, so I'm like, if the supporters are saying the bill died, that gives me reason for hope, unless it's 4D chess or something. We'll talk about that in a moment. Okay, so quick summary. The font's too small, my eyes are not what they used to be. So yes, unnecessary legislation, incorrect mechanism. What the bill does, you all know what it does. Big concerns, we have lots of concerns. Public and private school impact. As you know, the bill also impacts private schools. It would make it now mandatory that private schools, these are traditional brick and mortar private schools, file with ISB, currently Illinois State Board of Education. Currently that is a voluntary aspect. It would require everyone in a private school to have a high school diploma, even the janitor. And then the first version of the bill said that private schools needed to collect all the data on the parents and kids in the private school and then turn it over to ISB. The newest version of the bill that's currently pending on the House floor that was procedurally moved to third reading, that one just says that the private school needs to collect that information, but it doesn't require it to be submitted to ISB. Everyone knows here, and I hope you all realize this bill is just a starter. If HB 2827 ever became law in Illinois, the next year there'd be even more requirements. And so the Catholic Conference dropped their opposition, the Jewish schools, the Good of Israel dropped their opposition. Many of the other private schools have continued to oppose it. I told my friends at the Catholic Conference, I'm like, you do realize if this bill passes, that they're going to come back next year and do this. I know that Bob Gilligan, he testified alongside of me at the March 19th event. I know some homeschoolers have been really mad at him. Just again, Will Estrada, personally speaking, I'm very grateful to the Catholic Conference of Illinois. They came out early against the bill, and so I have no ill will for them. So don't send them hate mail. Don't send me hate mail if you're mad at them. I'm not Roman Catholic, so if you're Roman Catholic, you have a right to be mad at the Illinois Catholic Conference. Maybe we should edit that out if this live stream goes. I'm going to get myself in trouble here. Taxpayer impact, there's a big taxpayer impact here. The fiscal note of the bill said, yes, this bill will cost $1,600. And all of us were like, what in the world? I think Kirk Smith said it best. He said they can't even Xerox a piece of paper for $1,600. So this will have a massive impact on truancy investigations, the number of regional offices of education. Again, they are swamped with trying to enforce compulsory attendance on kids who are in the public school sphere. That, I think, closes it. Yes, that's our quick landing page about HB 2827. ICHE and Ad Hoc also have great information on it. And then there's my contact information. You can email me at will.estrada@hslda.org. Real quick, and then I'll open it up for questions. So your chance to stump the chump. Where is the bill right now? It obviously did not meet the crossover deadline, and so technically the bill is dead. There's a saying in Springfield that the Rules Committee is where bills go to die. However, having said that, this is Illinois. There are procedural rules that they can use to move a bill either into a shell or to just waive the rules and move it out. Both Chair Mussman and the sponsor, Tara Costa Howard, said, no, the bill is not dead. We're cautiously optimistic at this point. We're watching it very closely. I think it was very interesting to see that a lot of particularly the Black Democrat legislators in Chicago still have deep concerns with the bill. We've got some meetings scheduled with them, so the fact that they're willing to meet with us and with the Butlers and with other, Kristen Aziza Butler from Chicago, and with other Chicago homeschoolers is very heartening. And I think as long as those meetings are still going on, we cut out for a second. I don't think the bill will move. Having said that, we are watching it until May 31st. That's when the session ends. And then there is a 6-day veto session right around Thanksgiving. So I might be eating my turkey and then jumping on a flight here if need be around Thanksgiving. So those are some dates we're watching. As the Yogi Berra, the great baseball player, said, it ain't over till it's over. And this is the most important priority for HSLDA, to support our friends at Ad Hoc and ICHE and every single one of you in the Illinois homeschool community. So that's, I think, best guess of where we're at. Let's open it up for questions. So one final thing, I would just encourage you, consider donating to Ad Hoc and to ICHE. I love what I get to do, but frankly, if there was not such strong grassroots support already existing through Ad Hoc and through ICHE and through a lot of other allied organizations, I think this would have turned out very differently. You all have been coming to Cherry Pie Day for decades. It was the 35th annual Cherry Pie Day. They had Cherry Pie Day, ICHE did, even during COVID, which I don't know how they did that. I can share some amazing stories of things I saw firsthand 2 years ago at Cherry Pie Day, but I'm not because I don't want to get anyone in trouble. But suffice it to say, ICHE and Illinois homeschoolers have such a good reputation that the love for homeschoolers last year, not this year is a little more tense, but last year that I saw at Cherry Pie Day, that really speaks volumes to the reputation you all have because of your advocacy. And it doesn't start when a bad bill is introduced. You all have been doing that and building those relationships for years. And I think that's why we're here where we're at. 2 other final quick stories I'll tell, and then I will take questions. I'm not filibustering here, not trying to avoid taking questions. First funny story is when the bill was introduced, we had numerous kind of Springfield experts tell us, they were like, don't even try fighting in the House. It's going to pass in the House. You've got a good chance to kill it in the Senate, but it's going to sail through in the House. And it's been, and we thought about that. We talked about it, but Kirk Smith and Jeff Lewis, and I know they were talking with you at Ad Hoc, they said, no, we're like Winston Churchill, who said, we will never, never surrender. And we're going to fight this in the House, we'll fight it in committee, we'll fight it on the landing beaches, we'll never surrender. You know, Winston Churchill, kids, you know who Winston Churchill is, right? If you don't, go watch a Winston Churchill video when you get home and ask your parents. Winston Churchill was great, one of my heroes. And I have talked to senior Senate staff and lobbyists who were like, we have never seen anything like this. I was in Peoria at the homeschool conference, the Patch Homeschool Conference a couple of weeks ago, and I took the homeschool leaders out for dinner afterwards, and they're wearing their t-shirts, and we walk in, and the lady at the restaurant, upscale restaurant, she's like, are you homeschoolers? I mean, they had homeschool t-shirts and big family, so duh, of course they're homeschoolers. And then she's like, are we gonna beat that bill? And they're like, do you mean HB2827? And I'm like, I've never seen anything like this, and I've been doing this for 21 years of just everyone in restaurants knowing about bills, because you all, again, as I said at the very beginning, you have captured the energy and enthusiasm of not just homeschoolers, but the general public. And then, well, I won't tell that story because we're being recorded still. Sorry, you can ask your leaders to turn off the phones. I can tell the story. One other story I'll share, and some of you might remember this. During the hearing on March 9th, let's open it up to questions. And remember, you're being recorded, so keep it polite. Homeschoolers are polite people. We are nice people. Yes?
Do you know who Sheriff Richard Mack is?
Richard Mack? I don't know who Richard Mack is.
Oh,
All right, would you tell us who Richard Mack is?
okay.
First, introduce yourself.
I'm not going to talk
Okay,
to
okay.
You got to look up Sheriff Richard Mack.
All right, I'm making a note here. Richard Mack. My ad hoc friends are saying, did you say Sheriff Richard? As in like Sheriff of Nottingham?
Yes.
Okay, Sheriff Richard. Suddenly, poor Richard Mack, if he has like Google hits, he's like, everyone's searching for me. All right, is he alive or dead?
He's alive.
Oh, he is alive. Oh, he could know. Okay. Sheriff Richard Mack. Am I going to be like on a ATF watch list now if I Google him? Okay, good. All right, Sheriff Richard Mack. I will.
Anyway, he said, inalienable is not a word. The word is unalienable. It means you cannot put a lien on our rights. They are God-given rights. Inalienable is a non-word.
I like that. You all hear that? Unleanable. As in L-I-E-N, not L-E-A-N. I can lean. So, good thought. I'm going to Google that. Thank you. Appreciate that. Other questions, comments? Yes?
So, I actually went down to Springfield on the 19th, and they were using the leverage of abuse. And I know it was sympathetic with one of the speakers that said that she had a history of abuse as a homeschool kid. But they didn't, it was very anecdotal, and they didn't have any of the statistics, and then if you're gonna compare the numbers of abuse in
Yeah. Thank you for bringing that up. Obviously, there are kids here, so I'm going to be fairly guarded on what I say. So one of the two CRHE witnesses who spoke, first of all, the other one was a summer intern in 2006. I got one email. It was like, why did HSLDA send 2 lawyers to testify on the bill, one for the bill and one against? I'm like, no, that was a CRHE witness who kept mentioning HSLDA, but he was a summer intern worker in 2006. But 2 of the main CRHE witnesses who testified, obviously one was the gentleman, but one was the other lady, and I hope you all heard her testimony, because I'm sitting there listening, and I'm like, my heart went out to her, because that's a legit cult she was in, like David Koresh level cult. And as we all know, if you've studied cults and all the way back, Jim Jones and all that sort of stuff, that cults are a very weird thing that affect everyone: public, private, homeschool, people who are smart, people who are not so smart, people who are rich, people who are poor. So my heart went out to her, because that was a cult she was describing. That was not homeschooling. That was not what anyone would, by any stretch of the imagination, include to be homeschooling. But you're absolutely right. The stated purpose of this bill of Coalition for Responsible Home Education, of the Make Homeschool Safe Act, is to protect children from abuse. I encourage you, I mentioned at the beginning of my testimony on March 19th, I have a stack of research on this, and I was hoping someone would ask me about it, and none of them did. But Google Ray Shakeel. Ray is the last name of one of the researchers. Shakeel, Shakeel, Ray Shakeel, 2023 study, homeschool abuse. Ray and Shakeel, it's to the best of my knowledge the only peer-reviewed study that has come out on this topic. They did a study of are homeschool students at greater risk of abuse and neglect than kids in public and private school, and they found there's no statistical difference. Also, if you email me, if anyone emails me at will.estrada@hslda.org, I'll send you a draft op-ed I wrote. It was kind of a little too spicy, so I'll probably send you the edited version of it. Now you're all like, what? I want to see the real version. So it never got published, which is probably a good thing. But I go through the stats, I go through the federal data, and did you know Illinois is #1 in the nation for child fatalities? I'm sorry, number 5. Texas is 1, California is 2, Georgia is 3rd, Ohio is 4th, Illinois is number 5. There are numerous investigative reports, audits that have done about DCFS, the Department of Children and Family Services, about how badly they have failed the children of Illinois. The other interesting thing, heartbreaking thing, is that most abuse and neglect happens to 1 and 2-year-olds. It drops like this as kids reach 3, 4, 5, 6, and on. So statistically, we're not looking at very large numbers for public, private, or homeschool. You might remember that one of the CRHE witnesses, I believe it was the person who zoomed in, Jonah, if I'm remembering correctly, said that according to their research, 7 kids with some relationship with homeschooling had died of abuse and neglect. That goes back over 2 decades, 20 years of CRHE reporting. And at the same time, about 120 kids in Illinois lose their lives every year from abuse and neglect. So even if you look at their own research, and their research is awful, their database, CRHE has Elizabeth Smart, remember the Church of Jesus Christ of Latter-day Saints young lady who was kidnapped out of her home in Utah? They have her as a victim of homeschool abuse and neglect, which I don't know how you get that. She was a public school student who was kidnapped from her home and found later on, and she actually is today an incredible testimony of just resilience in the face of unimaginable suffering and heartache. But even if you take CRHE's data, homeschooling is like the safest way for children to be educated. So Google the Ray Shakeel 2023 study. I've got some additional studies as well, so email me, because the interesting thing was after the Ray Shakeel study came out, CRHE did a response. It was not peer-reviewed, it was just basically a response. And in the response, they say, we don't really care what the statistics show. Our mission is to regulate homeschooling. And I'm like, that's kind of the smoking gun right there of they really have no basis in evidence. And for 10 years, I dial it down. For 10 years, CRHE has been saying we're going to publish peer-reviewed studies about how homeschoolers are at greater risk of abuse and neglect, and I'm still waiting. I'm going to lose all my hair by the time they actually come out with this study, but it's been really interesting. So very good question. The evidence is just not there, but frankly, it seemed like a lot of the policymakers don't really want to look at the evidence. If Illinois legislators really want to protect kids from abuse and neglect, we've got to reform DCFS. And I don't care if this is being recorded. Are we in Terra Costa Howard's district? Or we're in Terra Costa Howard's district. When Terra Costa Howard was first elected, she came out of the gate very strong. Remember, she's a guardian ad litem. She has legal experience. I think she's an attorney. She came out of the gate very strong in, I'm going to protect children from abuse and neglect. The problems in Illinois with DCFS are huge, and they've been around for a while. And in 2021, she got a bill passed that put members of the legislature on an oversight committee to supervise DCFS. And then years went by, and nothing happened. And last year, the embattled director of DCFS, who has just, has really dropped the ball, stepped down, and she issued this statement saying, we thank him for his years of good work to protect children. And then instead of going after DCFS, she's going after homeschoolers. And I think she really dropped the ball on trying to hold government agencies that are failing to protect children accountable. That's what we should be looking at. If policymakers, we tried to meet with her. She said that we didn't, but we did. If I could sit down with her, I would say, Representative, thank you for your interest in protecting children, but we've got to reform DCFS, and here are several ideas on how to do it. But there's no interest in that because it's one of these government too big to fail agencies. There's probably other reasons they don't want to touch it, and that's the real thing we need to do to protect kids, especially here in Illinois, being number 5 of child fatalities. Good question. Yes? Oh, I'm glad you mentioned that.
It almost made it sound like, well, we're not talking about those who co-op because they're kind of like private schools. So are we actually private schools if they're co-op? Like, what are they saying?
I am so glad you brought that up. So the question, in case you didn't hear, was the amended bill. This was new. This was not in the first version of the bill. The amended bill, this is on page 3 of the amended bill. This is the one that's currently pending on the House floor. It says, it's a homeschool definition, so it's lines 19 through 26. It says, homeschool means a program where instruction is provided in a student's home environment and which may have more than one student so long as all students in the homeschool are members of the same household, except that students in homeschool are deemed private school, blah, 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 blah. Homeschool does not mean a group of 2 or more households who provide full-time instruction to students of separate households under a cooperative agreement or communal living arrangement. This is new language that was not put in any previous bill, and you're absolutely right. It would end co-ops. I think it would end homeschooling as we know it. And the really ironic thing is the stated purpose of HB 2827 is to get kids in front of mandatory reporters outside of the home, blah, blah, blah. And as you all know, where are we right now? We're in a co-op that's not in the home, where you're meeting with other parents and other children. Lots of families have many co-ops. There's classical conversations. There's this one and the excellent work that you're doing. Homeschooling is not just in the 4 walls of a home. The world, what was that line from the People versus Levison decision? That it's the whole world is our place of education. And by redefining homeschooling to just be in the home of one family, it would upend co-ops as we know them. An additional interesting thing is that the ISBE lobbyist was asked this in the hearing, and he said if even 2 moms meet together, they'd have to register as a private school. So here's the problem. You cannot register as a private school under ISBE regulations unless you are not in a home. And then you have to have 501c3 status. There's a litany of requirements. I think you have to comply with the Federal Civil Rights Act of 1964. But the key word is a home-based program cannot register as a private school. That's under ISBE regulations. So homeschoolers would be in this terrible bind. I think there's even a chance that co-ops could be shut down completely, and that you would only be able to operate if you were an official private school, background checks, 501c3 status, insurance, non-discrimination statutes, et cetera, et cetera. So that's a really, nobody's been talking about that. In some ways, even though we don't have the automatic criminal penalties, the new bill, because of this language, is worse than the previous version. So thank you for bringing that up. Thought I saw one or two more hands. Yes, in the back.
So I have a couple questions. I don't know if you want to answer these well, tell me or not. Do you know who's behind the money behind the CRA?
Yeah, so and then I'll get your other question. So CRHE is honestly a very lean budget. They're true believers, they're ideologues, their mission in life is to, actually the director's name is Kieran Darkwater, recently said on a podcast the United States should follow the German model of homeschooling because that's the correct model. And as you all know, Germany bans homeschooling. You know, we've assisted families to try and come here and claim asylum, like the Romica family. So these are true believers who want to end homeschooling. I think they are 990, that's the 501c3 IRS form, showed that they only brought in about $250,000 last year. So the founder of Ben & Jerry's gave them $60,000. Some other left-wing groups did. But the main thing is there is a movement, as we saw, you know, talking about that debate between the state and parents, that doesn't like parental rights, that doesn't like the family, that doesn't like freedom. And their ideology at CRHE is finding common cause with Elizabeth Bartholet, a law review professor at Harvard who wrote a law review in 2020 calling for homeschooling to be banned. Jim Dwyer at William & Mary Law School who wrote a book. Actually, the co-author of the book was just elected, or actually his wife was just elected to the Wisconsin Supreme Court, saying that the courts should take away children from parents who are homeschooling. So this ideology, you know, ProPublica is behind it. So CRHE is a small group. They're not getting massive funding, but they find common cause with a lot of those who control the media with legislators. Next question. I know you had several.
Not too many, please. Yeah, because I had seen during the run-up to the hearing some slides that the CRG had provided to the legislators. Have you saw those slides? That's kind of the thing where they were blatantly like anti-parent, anti-Christian. Yes.
I encourage you to Google. This is on the CRHE webpage. It's called Parental Rights Extremism Messaging Guide. Inexplicably, I mean, you're recording it, so they're going to see it. I don't know why they still have.
Supreme Court of the land, right?
Yes, yeah, that's U.S. Supreme Court. That's 1972.
Okay, so should we all become Amish then?
You know, the interesting thing is the kind of First Amendment jurisprudence since then has actually gotten very good. First Amendment religious freedom. The sad thing is, if you're a religious homeschooler, you probably have more legal protections than a secular homeschooler. And I think that's fundamentally wrong. I mean, you look at the founding of our country of William Penn and tolerance, everyone should have freedom, but because of the current jurisprudence, if you're a religious homeschooler, you don't have to be Amish or Mennonite, you can still drive your car. You probably have strong protections. Good question. I see one more question there, and then we're coming up on a hard time, and I'll let you go, but yes?
Oh, yeah, I just was wondering about the timeline that you said, so if it doesn't pass by May 31st, you said something about some.
There's a 6-day veto session right around Thanksgiving. I think it's 3 days, the week before Thanksgiving, 3 days after. Technically, they could try and ram a bill through. I don't personally think they could. No, because it's still part of the same session. Yeah, so the session only lasts till May 31st, but the veto session is technically still part of the 2025 session.
And is that typical that they'll take bills from that?
No, it's theoretically possible. It very rarely happens.
So if it were to pass by May 31st, there's still a year until it takes effect.
Correct. That's very important to note. The bill has a lag time of a year. If, as I'm cautiously optimistic about, the bill is defeated this year and they bring it back next year, this will be the 2026 session, they would push off the implementation date because they need time. I mean, this is not just a form. This is a massive change that's going to impact public education, private schools, and everything. So if it were to pass next year, it wouldn't go into effect until September 2027.
And would that, during that time, we hope it doesn't pass, but if it did during that time, would there be potential lawsuits then, or would it have to be after?
Yeah, so timeline on lawsuits, that's standing. When do you have standing? Then there's also something of, do you do a facial challenge? That means the law is unconstitutional in any way, shape, or form, or an as-applied challenge. That's like, well, as applied to the Smith family or the Amish, it's unconstitutional. I know there would be organizations who would be filing a lawsuit as soon as the bill were passed. So that would be either, let's say July 1st of this year or July 1st of 2026. I'm not sure if those lawsuits would prevail. I personally think, and you get 10 lawyers in the room, you get 11 opinions. So my personal opinion is we have better success on an as-applied challenge versus a facial challenge, which means you'd have to wait until the law goes into effect. But, we would be there, ADF would be there, ACLJ would be there. There's a bunch of other organizations that have reached out to me of expressing interest of lawsuits. But take heart, the bill has to pass first. We've already seen multiple iterations, so I've told people I would like nothing better than to sue this, but let's wait and see what happens. There'll be plenty of time to kind of look at, if the bill were to pass, what does it look like before we have that conversation. Final question, and then I'll hang around. I do have a 5:55 flight out of O'Hare today, but I live life on the edge, so I'll talk to you in the parking lot. Yes, ma'am, in the pink.
Okay.
Yeah.
So, I don't know how to ask this question, but are the people who contact you who are outside the homeschool community, but looking at this case because of the media attention, do they tend to be swayed one way or the other in terms of how they view the issue? Are they more on the CRAG side of things and how they think? Or are they more likely to lean more toward the homeschooling side, or do you get a feel for that?
That's a great question. So I did a radio interview with Chantel Moore, a Latina homeschool mom from Chicago, with kind of a left-leaning Spanish outlet. And by the end of the interview, the guy was like, as soon as the recording turned off, he was like, I thought this was a good bill. Now I hope it fails. So I think a lot of people, they're like, oh yeah, we want to protect children. And they kind of look at that initially, but then when they start digging into what does the research say, and that's why, ma'am, your question about the abuse and neglect was so important. When they start looking into what the research says and what the law will actually do and the success of homeschooling, they realize, wait a minute, this is a solution in search of a problem. This is a bad bill. So never underestimate the power that we have to be ambassadors for homeschooling. Because you doing that, kids, you being there and liking homeschooling, that speaks volumes, more than any lawyer flying in from Virginia can ever have. It's a good question. All right, we got time for your question and now break.
Super easy. For those of us who got here late, is this recorded and going to be available somewhere where we can see what you said at the beginning?
We're gonna try.
We're going to try to.
It has been recorded.
It hasn't
Oh
recorded.
no, it's been recorded. Well, yes, and Lincoln, and thank you for the opportunity to come and speak.
Thank you.